Hi, good afternoon, seniors. Sincere apologies for the late start. I had a bit of internet challenges, but it is all resolved now. My name is Fatah Mahama, Part 1 student, UPSA Group C. And let me not take any more of your time. Telfer is on the call, so he can begin. Thank you so much.
Great. Good afternoon, everyone. We are continuing our tutorial sessions in respect of the law of interpretation. Last week, we spent some time looking at statutory interpretation with specific reference to repeals and retrospective legislation. And as you are aware, the Supreme Court has just recently rendered its review decision in the Edmund Addo and Attorney General matter, which in effect affirmed the position it earlier took that the repeal or the, if you like, termination of a legislation by the parliament through an enactment does not necessarily invalidate the carrying out of a trial, a criminal trial, in respect of that offense. And so, by virtue of sections 34, 1D and E of the 1992, of the Interpretation Act 792, the repeal of an offense creating statute would not terminate criminal proceedings that have been initiated as a result of the commission of a crime. And the disposition is uh, contrary to what was established in British Airways and Attorney General. However, CA4, like I explained last week, which was the operative text in respect of the interpretation. Can you hear me?
Yes, we can.
Yes, sorry. So CA4, as I explained last week, which was the operative text in relation to interpretation of statutes in Ghana, at the time the 92 Constitution, at the time British Airways was decided, it's different from the provisions or 8.1 to E in respect of CA4 is different from section 34.1D of the Interpretation Act. Specifically, the word or the term offense did not find presence in CA4, but you'd find that it is present in section 34.1D. And so I guess the matter has been conclusively settled and the debate has ordinarily should come to an end. I mean, there are still those who take the view that Edmund Addo was wrongfully decided. Uh, I I can understand where they are coming from. I do not agree with them. I think the Supreme Court made the right decision in respect of the interpretation of the law. And further, that is now the position of the law anyway. So in your discussion of repeals and retrospective legislation, you are mandated to discuss the position of the law. And so I encourage you to read Edmund Addo and Attorney General, the original Supreme Court decision, and the review decision of the Supreme Court. In fact, this is one of those review decisions where the Supreme Court didn't merely say that its review jurisdiction has not been met. As you are aware, it is difficult oftentimes to get the Supreme Court to review its decisions. They say it's easier for a cow to go through the eye of a needle than for the Supreme Court to review its decision. And so, ordinarily, in such matters, the Supreme Court will simply say their review jurisdiction does not arise, and so they will not proceed to deal with the claims. But in this matter, you would see that Justice Amadou Tanko went into the gravamen of the claim of the plaintiff in that matter, and then dealt with why the position, as affirmed by Justice Asido in the previous decision, was the correct position of the law. And so the Supreme Court unanimously upheld that to be the current state of the law as it relates to the repeals of an enactment in Ghana. Great. Today we are beginning what would be a two-part series on our discussion on ouster clauses. Now, ouster clauses, it's a lot. Yeah, it's quite involving. So, but I would not, we would not be able to exhaust everything that we have to discuss in respect of ouster clauses in one session. We'll do that in two sessions. And so this week, we'll begin the discussion on ouster clauses, and hopefully next week, we can conclude ouster clauses and then move on to another topic. The beautiful thing about ouster clauses is one of those topics that, if you look through the past questions, it is a, for want of a better expression, is a usual suspect. So it is important that you ground your understanding on ouster clauses, and then we are able to make progress in that respect, so that at least you know that you have significantly conquered one area. I mean, two now. I mean, now you are expert on repeals and retrospective legislation. So I do not doubt your ability to discuss that. Great. Let me share my screen. But before we begin ouster clauses, if you have any questions, you may please bring in relation to what we discussed last week, or generally any questions that you think you want us to discuss now. Please bring that up now. Let's spend some time to look at it. Absent that, we may proceed. So please, any questions? Great. We'll assume there are no questions. So today we are looking at ouster clauses, and ouster clauses form part of the law of interpretation, because oftentimes the interpreter, the judge, will be called upon to determine the effect of an ouster clause, and if same is binding on the court. And so ouster clauses are discussed as an important part of the law of interpretation. And ouster clauses are, if you like, born out of the understanding that the jurisdiction to resolve disputes generally vests with the courts of competent jurisdiction. So the courts, as they are variously structured, have the jurisdiction to determine matters of law and of fact. And when they have determined matters of law and of fact, of course, of a binding effect, and parties are compelled to comply with the decisions made by these tribunals, courts, and adjudicatory bodies. And so, based on that understanding, they, under common law, in terms of historicity, there was a certain understanding that oftentimes you could prohibit the ordinary or regular courts from dealing with certain matters, and that in doing so, you are attempting to limit or completely oust the jurisdiction of a court in relation to a matter. So take it from this point. Generally, parties who have a dispute are entitled to go to the courts depending on the nature of the dispute, which will determine what court has, if you like, the capacity to hear the matter. Then the court would make a final and conclusive determination of the matter. That is the general position, is that subject to or based on a civil society where there's an understanding of the rule of law, when parties have disagreements as between themselves, they do not take up arms. They decide to pursue the courts of law as a credible means of resolving their disputes. Having established that, at the common law, a certain trend began to grow where, either at statute or by the private arrangement of the parties, they decided to limit or oust the jurisdiction of the courts in relation to their matters. And so people began to come up and say that, look, we agree that whenever a dispute arises, it is important for us to go to court and resolve the dispute. However, in relation to certain categories of disputes, we do not want any intervention by the courts, because to their minds, and for a plethora of reasons, for instance, the court process may be long and arduous. It may potentially create situations where there's enhanced scrutiny over their business activities or their personal affairs, or there were situations where people just didn't want a situation where somebody who had no expertise or knowledge over the matter would be sitting in the court and making a determination as it relates to their dispute. And so the trend began to develop where parties began to accept ouster clauses as part of either a contractual agreement or arrangement, or ouster clauses provided for by the lawmaker in statute. And so when we say ouster clauses, what we simply mean is those category of provisions that can be embodied in a document, a statute, or a constitutional or a constitution. So when we say DSC, that's what we mean: document, statute, or constitution. So those provisions that may be found in documents, statutes, and constitutions, which seek to remove the power of the court to make a determination of the matter. So they limit or restrain or oust, entirely remove the power of the court to hear a particular matter, either partially or in totality. And so you'd see that in Kwachi Attorney General Apalo CJ, in his opinion, outlined that Section 15.2 of the transitional provisions of the 79 Constitution contains what lawyers refer to as ouster clauses, which indicates that it ousts the normal jurisdiction of the court. And so that is the background to ouster clauses. Those provisions that exist either in a document, in a statute, or a constitution that ousts the normal jurisdiction of the court in respect of any disputes that may arise in those instances. Now, our understanding of ouster clauses are such that they can be classified according to where they can be found or what they purport to do. Ouster clauses can be classified according to where they can be found or what they purport to do. So the simplest form is where they can be found. So you see that there are three main forms of ouster clauses: those that can be found in the Constitution. So for instance, in the 92 Constitution, which is, so the transitional provisions are similar in form to what we had in 79, that oust the normal jurisdiction of the court in relation to the certain matters. So acts and omissions committed by the PNDC during the pendency of the military regime are ousted or removed from the ordinary or the normal jurisdiction of the court. What this means is that the court, no matter the way in which the relief is framed, is stopped or prevented from going into a matter or a situation where a person is alleging that any act or omission conducted by the PNDC, say for instance, was inconsistent with their rights. To the extent that Section 34 of the transitional provisions expressly provides for this constitutional ouster, and then no court in Ghana can admit any such claim as a result. So a constitutional ouster is what is contained, or is an ouster clause that is contained in the Constitution. An example is Section 34 of the transitional provisions of the Constitution. Then there are those found in private documents or agreements, also known as non-statutory ouster clauses. Now, these ouster clauses are found in contracts, international agreements, constitutions, regulations of various organizations, and other private bodies, which seek to oust or restrain the jurisdiction of the court in certain matters. And so it is not strange to find that parties in a written agreement would seek to do away with the power of the court to interfere with the determination of their legal relations, and they may agree that they will only resort to the courts after the breakdown of the internal mechanism. So you will find that in many collective bargaining agreements, in many private arrangements between parties, they will say that any dispute arising as to the operation of this agreement or this contract shall be subject to the negotiation of the parties, failing which the parties shall submit the dispute to arbitration. And so, I mean, you are all ADR experts, so you know how arbitration agreements are drafted. So an arbitration agreement is a good example of where the parties have voluntarily decided to oust or restrain the normal jurisdiction of the court in certain matters. Because as between me and you, when we've entered into a contractual arrangement and I'm in breach of my duties under the contract, the High Court or even the Circuit Court, depending on the nature of the claim, would have jurisdiction to determine whether or not there has been a fundamental breach or a breach of the conditions set out in the contract. And when that determination has been made, they can grant me the appropriate remedy. However, you and I may enter into a contract where we say that, look, even though we recognize the power of either parties to submit their dispute to the courts, we do not think it makes sense or it makes business sense to have our matters, if you like, venerated or dealt with in the courts of competent jurisdiction. And so we would prefer a situation where we deal with those matters in-house through a private negotiation of the parties. And even when our negotiations have failed, we would try alternative dispute resolution mechanisms such as arbitration. We would only resort to the courts when there has been a total failure of the internal mechanisms that we have set up. That is the idea of ouster clauses in a private document. Much more on that later. And then there are statutory ouster clauses, which are provisions you would find in a statute that seek to restrain or oust the normal jurisdiction of the court in special matters. And our, if you like, our statute books are replete with such situations where we have specifically farmed out the resolution of certain matters, certain specific matters, to bodies that are not courts. So, for instance, chieftaincy. We say that when it comes to a cause or matter affecting chieftaincy, it has to do with the chieftaincy tribunals and not the High Court in exercise of its normal jurisdiction. And so these are examples, or these are the ways in which you may classify a statutory, you may classify ouster clauses, depending on the document in which they may be contained in. Moving forward, ouster clauses may also take different forms such that they may be total or complete ousters. So a total or complete ouster operates that in such a way that under no circumstance will the court have any jurisdiction to hear the claim. Under no circumstance. So you find, for instance, that section 34 of the transitional provisions is a good example of a complete ouster clause, where the court's jurisdiction has been completely thrown out or completely restrained in respect of matters or activities that were conducted by the PNDC under the military regime. And on the coming into force of the 92 Constitution, any such actions, to the extent that it purports to question such activities undertaken by the PNDC, will be found to be now, or will be found to not warrant or invoke the proper jurisdiction of the courts. So that's a total or complete ouster. Then there's a partial ouster. A partial ouster says, in certain matters, the court would have jurisdiction. However, in certain other matters, the court will not have jurisdiction. So, for instance, parties can determine that when it comes to matters of fact, the court will not have any jurisdiction. But when it comes to matters of law, the courts would have jurisdiction. So that's a partial ouster, where the court's jurisdiction, not holistically, but in some form or in some part, has been limited, and then in some other parts, the court's jurisdiction will continue to operate. Then there's an ouster clause that postpones the jurisdiction of the ordinary courts for a certain period only. So the jurisdiction will be such that it is a deferral clause. And what it means is that there has to be the occasion of a specific event, which we'll talk about shortly, that will arise. And when it arises, then we'll say that the court's jurisdiction will now be properly invoked. And so the deferral clause operates in such a way that we are not saying the courts should not have jurisdiction over the matter. All we are saying is that the court should not be the first instance. And so you must defer to the internal mechanisms first, or something must happen first before now you can invoke the jurisdiction of the court in respect of the dispute that you are bringing before the court. And so generally, this is the view that we take. On the coming into force of the 1992 Constitution, the law as it pertains in respect of ouster clauses has changed. What the 1992 Constitution has done is to indicate that there's no such thing. So apart from constitutional ousters that are found in Section 34 of the transitional provisions, for example, the courts in Ghana have jurisdiction over every matter, of course, subject to the limitations that we will discuss. But what the 92 Constitution has done is to say that no clause in statute or in a private arrangement can purport to completely oust the jurisdiction of the court. So there's no situation that a party can say that under any circumstances, the court will not have jurisdiction over this matter. We'll come to why that is important shortly. But the understanding you must have is that on a reading of Article 1255 of the Constitution, the jurisdiction of the court is such that they are vested with the power to determine all matters, both criminal and civil. And so, what our understanding now is that you may attempt to postpone or restrain or limit in some form the jurisdiction of the court. What you cannot do is to completely oust the jurisdiction of the court. And so our understanding of ouster clauses in Ghana must be subject to that practice, which is entrenched in law now, that under no circumstance can the jurisdiction of the courts be completely ousted. They can be ousted in terms of a deferral or a postponement or a limitation in some form. However, on a general understanding of a complete ouster of the jurisdiction of the court, that is not applicable in Ghana as it pertains under the 92 Constitution. Please, is this clear? I need for this to be clear before we move on.
This is not applicable to the Constitution, right?
Yes, of course, it's not applicable to the Constitution.
Strictly statute and private documents.
Yes.
Okay, thank
So
you.
a statute or a private document cannot or may not purport to completely oust the jurisdiction of the courts. Any other questions or clarification?
Yes. Hello. Please, can you help me
Yes,
with the
please go
source
ahead.
of this particular statement? Yeah.
Okay,
My
so
question
we are doing.
source.
Yeah. Please go ahead. Finish your question, please.
Yeah. You said that no statute can completely oust the jurisdiction of the court, and I wanted to know whether you are actually quoting from a particular source, and if so, what section or article?
Okay, so we are building.
Thank you.
So we are building. When we get there, I'll point that out to you. Okay. Please, I hope that is fine.
Yes, please.
Okay.
Thanks.
Great. So we've spoken briefly about constitutional ouster clauses, and you would see that the indemnity provisions is a good example, but also in relation to matters in terms of what is the exclusive jurisdiction of the Supreme Court, in terms of enforcement and interpretation of the Supreme Court, in terms of the Constitution. What you'd realize is that even though the High Court is granted powers in all matters, civil and criminal, based on Article 141, it is subject to the jurisdiction of the Supreme Court in certain matters, which matters have been outlined in various provisions of the Constitution. And so the High Court's jurisdiction in terms of the interpretation and enforcement of the Constitution is limited to that extent, and many other repeats with many other provisions. So constitutional ouster clauses, fairly straightforward, not necessarily controversial, as I've explained above and also in section 34 of the transitional provisions. You may also see at least an Attorney General where the Supreme Court explained what the effect of these indemnity provisions in the transitional provisions mean and why they would operate to prevent the court from going into such matters, no matter in which way the relief has been couched by the parties. Let's look at ouster clauses in private documents. Now, in relation to private documents, or as respects or as regards private documents, what you would find is that a private document may have a complete ouster clause as it relates to matters of fact and of law, and it may have deferral ouster clauses that defer the jurisdiction of the court for a specified period of time. And so the complete one is the first one that we'll look at. So the parties to the contract are free to determine by virtue of the freedom of contract, which is an important principle at common law, that as much as possible, public policy does not seek to restrain the bargaining of the parties. And so when the parties have determined for themselves that they do not intend to pursue the court of law as a means of resolving their disputes, it would be the general position of the court to give preference or to give validation to such an arrangement. And so parties are free to engage in contract where they exclude the courts in respect of the determination of certain matters as and when disputes have arisen. However, in relation to this particular instance, they cannot purport to indicate the finality of the determination of that dispute to the exclusion of the court, arising out of the fact that that particular attempt to do so will be contrary to public policy and will be held to be invalid. The point is this, that admittedly, parties are free to determine the finality of the fact as it governs their relationship in respect of the contract. So the parties can exclude the court's application in that instance. What they cannot do is to exclude the jurisdiction of a court in respect of the legal rights of the parties and the remedies available to them in that instance. And so understand it simply that the position of the common law had been that in respect of matters of fact, the parties can exclude the court. But when it comes to matters of law, as it relates to the legal, for example, as it relates to the legal rights of the parties, no contract, no agreement can exclude the jurisdiction of the court. And so you would find, for instance, in the case of Lee versus Showman's Guild, so this should correct it to read Showman's Guild of Great Britain, where Lord Denning outlined that even though the jurisdiction of a contract can provide for a domestic tribunal to determine the dispute as between the parties, this is subject to limitations imposed by public policy. So, for instance, the tribunal must observe the principles of natural justice. They must give a person the notice of a charge and a responsible opportunity of meeting it, and that any stipulation to the contrary will be held to be invalid. Any limitation that purports to make the tribunal, i.e. the domestic arrangement of the parties, the final arbiter on questions of fact will be valid. But however, it cannot make it the final arbiter of questions of law. So in understanding Ouster clauses adopted by the parties in private arrangement, you must understand it this way, that the parties can determine that in relation to the disputes as between them, they prefer that an internal mechanism or some other tribunal other than the courts determine the matter. And they may even go so far as to say that when it comes to questions of facts, that tribunal should determine the matter, and the courts would uphold same. However, when they go into the realm of the questions of law, for example, as it relates to the legal rights of the parties, any attempt to restrict the ordinary exercise or to restrict the exercise of the jurisdiction of the court will be invalid and contrary to public policy. So that is the position that we establish in respect of the first ambit. Second ambit. The Ouster clause can also purport to postpone the jurisdiction of the court pending arbitration, negotiation, or the exhaustion of local remedies as between the parties. In this respect, the courts will generally recognize such clauses and give effect to it. And so, for instance, you would find that in the case of Nikwe against Ghana Film Industry Corporation, the court had no difficulty in giving effect to the Ouster clause contained in the collective bargaining agreement signed by the workers at Ghana Film Industry. In that case, the court was of the view that the disciplinary committee had been set up to investigate such matters that the plaintiff had brought in the High Court against the company. And so there was a remedy available to the plaintiff in respect of the disciplinary committee, and he should have deferred to the disciplinary committee first and exhausted that local remedy before attempting to bring an action in court. And so in that instance, the court dismissed the matter and found that there was a procedural ouster a temporary ouster that deferred or postponed the jurisdiction of the court. And so to that extent, it was not appropriate for the court's jurisdiction to be invoked in respect of that matter. However, in instances where the plaintiff must first exhaust internal remedies, the courts will still intervene under certain circumscribed or outlined instances. So, for instance, in a Sylvia and Tete, the court outlined that it is not its position to interfere with the contractual provision of the parties. And so, where the parties have engaged in a contractual provision that is not contrary to public policy, for instance, the adoption of a temporary ouster, the courts will not interfere. However, there are situations where, if the plaintiff is able to show that the issues in the disputes are to be better determined by the courts, or the parties have shown by their outward appearances, by their indications, that they do not intend to be bound by the domestic tribunal, or they do not intend to be bound by resort to the domestic tribunal, then the courts would intervene. So, to put it more forcefully, recourse to the courts is available to every party. The court does not permit a permanent ouster of the jurisdiction of the courts. And so, to the Mr. Lansdott, I believe, who asked the question of where am I getting my authority from, you should see a Sylvia and Tete first, number one. I'll give you more authorities as we go along. And so, contrary to the position that some may have, it is inconsistent with public policy for any party to permanently oust the jurisdiction of the court. The court will not give recognition to any such arrangement. What the courts are willing to give recognition to is a situation where the jurisdiction of the court has been postponed or deferred, such that an internal mechanism or some other means must be complied with before the jurisdiction of the court is invoked. So, for instance, if there's a disciplinary committee, go to the disciplinary committee first, failing which you may then invoke the jurisdiction of the court. Or if there's some other grievance remedial system, use that system before you defer to the courts. And this can be contained in the private arrangement of the parties. When it is contained in that private arrangement, the court would ordinarily give credence to it. However, this position is not without exceptions. And I've outlined that the general understanding is, if the courts believe that the issues raised in the dispute are matters that should be decided by the court itself, or the parties by their actions and their omissions have given the impression that they do not intend to use the domestic tribunals or the local remedies, then the court will dispose of with the ouster clause and proceed to hear the matter. So, for instance, in a Sylvie and Tete, the court provided us with 5 grounds under which, even in the presence of a procedural ouster, even in the presence of an ouster clause in a contract or a private arrangement, they may still intervene to hear the claim, and the court may still have jurisdiction. The first of the 5 is that when there's no competent domestic forum, or the process for initiating the forum isn't properly set up. So, for instance, you say that when a worker, so there's a collective bargaining arrangement as between workers of, say, for instance, GPRT, and they said GPRT will set up an adjudication tribunal to deal with all matters between the drivers and, say, for instance, the mates. And a driver has an issue against the mate. The procedural ouster clause indicates that he must defer to the GPRT adjudication tribunal before going to court. However, that tribunal has not been set up, or the process for initiating the matter before that tribunal has not been properly outlined, and so there's no clear understanding between the parties. In that instance, the court will not watch on for the party to be without a remedy. So the absence of a competent domestic forum or an appropriate process for initiating a challenge in respect of a breach of rights, say, for instance, under the arrangements complained about, would render a situation where the courts would have jurisdiction to hear the matter. So that is one. The second one is when the matter concerns purely questions of law, which a court is better suited to handling. I think I explained this a little earlier. So in situations where the dispute that arises relates specifically to matters of law and not matters of fact, and such that it requires the competence and expertise of the court to determine the questions of law, then to be more appropriate for the court to set aside the procedural ouster and proceed to hear the claim. The third one is when there's a threatened breach of the rules of natural justice. So when I was outlining the dictum of Lord Denning in Lee versus Showman Guild of Lee versus Showman's Guild of Great Britain, I outlined to you that the principles of natural justice, even in the presence of an ouster clause, must be observed. And so if there's a threatened breach of the rules of natural justice such that the setting up of the administrative tribunal or the domestic tribunal is inconsistent with the ethos or the principles behind natural justice, then there'll be no point. Say, for instance, we have my GPRTU example again. GPRTU has an administrative tribunal, or sorry, an adjudicating tribunal. And it indicates that when drivers have disputes with the mates, they are supposed to submit it before that tribunal. And you have a one-man tribunal that is chaired by the driver who is initiating the petition, and he's the only one who can sit on the matter. In that instance, that is a situation that occasions a threat to the breach of the rules of natural justice. And so it would be appropriate for a party to seek some other remedy than to defer to that remedy set up by the contract or the agreement of the parties. And so when there's a real likelihood or a situation where a party's rights in terms of the principles of natural justice are likely to be breached, it is okay for the party to bring an action in court to challenge a particular situation, even when there are domestic remedies available to the parties. You may see the case of Accra Hearts of Oak and GFA, the Ghana Football Association as well. Number 4, when the parties have shown by their conduct that they do not intend to observe the provisions of the agreement, i.e., they have indicated that they themselves do not have any regard for the domestic tribunal, or do not intend to apply that process that they've adopted for themselves, then it will be okay for the courts to, have jurisdiction to hear the claim. Because again, it is a private agreement of the parties. They have said that we will defer to internal or local remedies and exhaust them before we go to court. But if they decided to abandon these local remedies and they decided it is not, if you like, agreeable to their interests, or it's not something that they are willing to comply with, given the circumstance, the court will willingly forgo it and then proceed to hear the claim as having jurisdiction to do so. Then the final one is where a statute has reserved the decisions on the matter in question for the courts to the exclusion of any domestic tribunal. So in a situation where it relates to certain matters that the jurisdiction has been vested in the courts by statute, a private arrangement of the parties cannot purport to limit the jurisdiction of the courts in those matters. And so it will be wrong or erroneous on the part of a party to attempt to do that. And that is one other instance that the court may then have jurisdiction. Any questions? So what we see from Sylvia and Tete and the exceptions we've outlined there too is that the general position is that when there's a procedural ouster clause, the court will give effect to it. However, under certain circumstances, and these 5 circumstances we've outlined, the court may still intervene and the court may still have jurisdiction in respect of the dispute that has arisen, even though the parties have failed to exhaust any local remedies. Any questions, please? So the point that has to be made is this, that because the parties do not have the power to completely oust the jurisdiction of the courts, what they can do is that when a person has brought an action in respect of a matter, which party should have deferred, say for instance, there's an arbitral clause or there's an arbitration agreement situated in the contract as executed by the parties, the remedy available to the parties is not to, throw your hands in the air and say, well, you should have exhausted domestic remedies. Once a party has acted in breach of that arrangement, you may bring an action for a stay of proceedings so that they can comply with the domestic remedies that have been set up first before the court can proceed to hear the claim. But again, it doesn't limit the power of the courts to go into it and say that based on the exceptions that we are aware of, there may be a situation where we can intervene. But generally, when the courts have decided they will not intervene in respect of procedural ouster, the remedy available to the party is to apply for a stay of proceedings and then have the party comply with the exhaustion of local remedies. Private ouster clauses. Any questions? Shall we proceed, please?
Yes, please.
Great. Let's look at statutory ouster clauses. Now, just as we explained in relation to the general understanding, just 1 second, please. Just as we explained, in relation to the general position of ouster clauses, you may find sometimes in statute that by express or necessary implication, a statute has restrained the ordinary courts from dealing with certain matters or from exercising any supervisory or review powers over lower bodies or tribunals that have been granted the power to deal with such matters. And as I've outlined, the statutory ouster clause may take several different forms. They can be procedural in nature, they can be partial, they can be total. Now, in terms of partial ouster clauses, they oust the jurisdiction of the court in specific matters. So, for instance, an ouster clause that confers the exclusive jurisdiction on an inferior body or tribunal, but it does not take the jurisdiction of the ordinary courts to review those decisions away from it. So, for instance, you see that when it comes to causes of matters affecting chieftaincy, the ordinary jurisdiction of the courts have been ousted, but the appellate jurisdiction in respect of matters coming out of the House of Chiefs and the review jurisdiction in respect of the exercise of prerogative rights for the High Court and the Supreme Court is still present. Now, Parliament has the power to set up domestic tribunals or internal remedies where those remedies must be deferred to, or those mechanisms must first be deferred to before a party can bring an action in the court. So, for instance, you'd see that under the 1 second, please. In the case of Boyfield against NCHC Properties, the court was determining the effect of Section 13.2 and 13.3 of PNDC Law 152, which provided that appeals from any decision of the adjudication committee ought to go to the High Court. But what it meant was that the Land Title Adjudication Committee had been set up by PNDC Law 152 to determine disputes arising out of the conduct of the land title registry's functions. And so when it came to land title registration matters in Ghana, it appeared, or it was the case, that those disputes were to be resolved by the Land Title Adjudication Committee. And the Supreme Court has clarified that when a specified procedure or a special procedure has been set out by an enactment for something, for the way something ought to be done, that procedure alone is what is to be complied with. And so that is a good example of Parliament. Is there a question? Okay. That is a good example of where Parliament would do that. Now, in the past, and this goes back to my point on the limitation of a statute to purport to completely oust the jurisdiction of a court. In the past, ouster clauses existed where, after giving an inferior body or tribunal with exclusive jurisdiction of the matter, the review jurisdiction of a superior court to deal with that matter was severely limited. And so you'd find that the terms or the statutory words would find the expression that such a decision shall be final. And so let's spend some time to clarify the current position of such legislation in Ghana. So, like I mentioned, there may be a situation where the provision of law. So, for instance, if you look at Section 47 of the Subversion Decree, it provided that, and I'm quoting it, the decision of a military tribunal appointed under this section shall be final, and no appeal shall lie from such a decision. And Section 93 of NRCD 172, which was the Stool Lands Boundary Settlement Decree, also provided that any findings or decisions published under the decree was to be final and was not to be questioned in any courts or elsewhere. And so I guess my question is, if Parliament makes a legislation today and says that, say for instance, when it comes to matters relating to let's use an example such as the revocation of the banks that has happened recently. So Parliament sets up a Bank of Ghana Amendment Act, which gives the Bank of Ghana the power to revoke licenses. And when the Bank of Ghana has revoked the license of a bank, the bank can make an appeal to the, let's say, the BOG Adjudication Tribunal. And the statute will indicate that the decision of the BOG Adjudicatory Tribunal shall be final and no appeal shall lie from such a decision. What do you think the effect of such an ouster clause would be? What do you think would be the effect of such an ouster clause? Did you get my question?
Please ask it again.
So my question is this. The Bank of Ghana Amendment Act has been passed. Let me type it so that everybody can get it. Yeah, just 1 second. Please, you see the question?
Yes.
Yes. What do we think?
I'm thinking this would be a statutory or Ouster trying to invoke a complete Ouster on the jurisdiction of the court. And I think that cannot be done. Aside the constitution that can invoke a complete Ouster on the jurisdiction of the court, the statute doesn't have that authority to do that. So if such a thing is put in the BOG Amendment Act, I think an aggrieved bank can bring up an action to the effect that this is in contravention with the the jurisdiction of the court. Maybe come under Act 1255, that the court has the mandate to deal with civil and criminal matters, and this seems to us that jurisdiction of the court.
Okay. Well,
Daniel?
Yes, go ahead.
Okay, so I also think that to the extent that this becomes a statutory provision, we need to respect the statutes as they are. To the extent that you need a party who is aggrieved by the decision of the arbitral tribunal, the BOG, can bring an action rather to set aside the decision of the tribunal, but not necessarily to appeal, because appeal will be some kind of forward-looking in terms of staying the status quo of the decision, but then a setting aside would be to quash the entire process that the tribunal would have conducted.
Can you come again, please? I missed. I lost you at some point.
Okay, so I was saying that I'm thinking that to the extent that the statute has prescribed a manner in which a certain procedure of revoking licenses should be done, we need to respect that. And then an aggrieved party who appeals to the tribunal, and the tribunal gives a decision, to that extent, that decision is final and binding on the parties. I'm thinking that because this is statute, what a party can do is to invoke the superior court's jurisdiction to quash that decision or set aside that decision, and not necessarily to appeal it, because the statute says you cannot appeal it. So it
Okay.
will remain aside, but you
If
can
I
set
get
this
you
aside.
correctly, what if I get you correctly? You believe that the matter can be questioned on review, but when it comes to the appeal, we must respect the provisions in the statute. Not so.
Very well, senior. That's exactly what I'm saying.
I want another view, please. Another view, please. It's a discussion, please. I want another view, please. We will not move on now, because we need to settle this once and for all. So please, another view. Or the question is not clear. Should I clarify? People of God, another view.
Yes, clarify, please.
Okay, so this is the question. This is the stipulation. This is section 3.1. The question is, so let me add something. Is there clarity, please? So this is the question. Now that I've clarified, what do you think? We don't think. We don't think anything. Okay. The answer is in the following cases. Great. Let's proceed.
Oh, wouldn't you tell us what you think?
People are not telling me what you think, so
But at least two people have spoken.
Okay, so let me try and tell you what I think before,
yes.
so you can help us. Okay. What I saw is that it says that what no appeal shall lie after a person has what submitted his grievances to the tribunal. I think for me, I would think then it appears to sin against the decision is in a Sylvie versus Tete, which says that no, apart from section 34 of the transitional provisions, no statute shall oust the constitution of the courts. That's my view.
Okay.
Thank you.
But then we already have a similar provision in statutes in respect of chieftaincy matters. Let me clarify what it is. So the question evokes two, you must look at it from 2 points. That generally, when an internal tribunal has been set up and there's an attempt to limit the jurisdiction of that tribunal, what the legislature will try to do is to restrict the right of appeal or the right of review. The clarification that ought to be made is that the clause as it stands, there's nothing wrong with it. The fact that the decision shall be final and no appeal shall lie from such a decision, prima facie, if you look at it, it's fine. But you must break it down to two parts. The part that relates to shall be final and the part that relates to no appeal. The legislature can provide that after the BOG Adjudication Tribunal has determined the matter, there's no right of further appeal in respect of that matter. That can be provided for. But in respect of the exercise of the review jurisdiction, i.e., shall be final, the legislature cannot purport to restrict that by virtue of the applications of Article 132 and 141 of the Constitution. We'll come to that later. But the point is this: a statutory ouster clause may limit the jurisdiction of the court in respect of the appeals of matters. So you realize that when it comes to causes of matters affecting chieftaincy. When the chieftaincy tribunals have heard the matter, the High Court has no jurisdiction in respect of an appeal. So when the traditional council has heard the matter, you go to the regional house, you go to the national house, and then appeal to the Supreme Court. If you have, with the leave of either the Supreme Court or the National House of Chiefs. But the point is this, that you cannot appeal to the High Court in respect of causes or matters affecting chieftains. That is fine. However, when it comes to the exercise of the review jurisdiction of the High Court, no statutes can purport to oust the jurisdiction of the High Court in that sense. And so the point I was trying to draw your attention to is that when it comes to statutory ouster clauses, they may limit the right of appeal, or they may limit the jurisdiction of a court in respect of its appellate ambit. But when it comes to its review ambit, especially in exercise of the supervisory powers that the High Court and the Supreme Court enjoys, no statute can purport to oust it. Do you get the clarification?
No.
Let me take it again. When a lower body has made a decision, say for instance, you've brought an action in the High Court, there are two, and then you are disgruntled or you're unhappy with the decision of the High Court, there are two options available to you to challenge that decision. You may appeal the decision, especially when it relates to matters of fact and of law. You may appeal the decision, or you may invoke the supervisory jurisdiction of the Supreme Court in respect of that decision, arguing clear grounds. So, for instance, when the decision has been made in breach of the rules of natural justice, and when there's an error on the face of the record, when there's a want or an excess of the jurisdiction of the High Court, these are all situations where you may invoke the supervisory jurisdiction of the Supreme Court to, if you like, quash the decision of the High Court. Those two ambits. And I'm saying that the power that the legislature has is to limit your right of appeal, or to limit the jurisdiction in respect of a court to hear the matter in exercising its appellate jurisdiction. So, for instance, in Ghana, causes or matters affecting chieftaincy, the High Court has no appellate jurisdiction. The High Court's appellate jurisdiction has been completely ousted in respect of causes or matters affecting chieftaincy. However, it does not derogate from the fact that the High Court still has supervisory powers over chieftaincy tribunals. And so when a person is alleging that certain things have happened that are, say, for instance, in breach of the rules of natural justice, want or excess of jurisdiction, error on the face of the record, the person is entitled to question it in the High Court. And the point I'm making is, when a statute has said that the decision of the tribunal shall be final and no appeal shall lie from such a decision, we can take the part that says no appeal shall lie from such a decision, hook, line, sinker. But the decision of the tribunal cannot be final, in the sense that it cannot be final as it relates to the review jurisdiction of the High Court and the Supreme Court, which review jurisdiction is granted by the Constitution, and which review jurisdiction cannot be taken away by any statute, because then same will be inconsistent with the provisions of the Constitution. So, in understanding the true legal effect of the term shall be deemed final or shall be final, it must be limited as much as possible to our understanding on when it comes to appeals. However, it does not, or it cannot, extend to situations where it relates to review. And final judicial power is vested in the judiciary in Ghana. So no legislation can purport to take that away. And we are saying that in terms of appeals, that limitation is acceptable. But in terms of the review jurisdiction of the court, that limitation is unacceptable. And no legislation, no matter how cowed, can purport to take that away. Does this make sense now?
Definitely.
Any questions, clarifications, please? Dodi, please, are you fine now?
Yes. So that means when such a question is given you, you
Mhm.
don't need to go on a tangent of saying that it's trying to completely or is the jurisdiction of the court. That is not what you should look at it from, but rather look at it from the term of the final and the no appeal. Is that it?
So look at it from the point of what the interpretation our courts have given to the term shall be final means. What our courts have told us is that when a legislation contains a term shall be final and conclusive, it does not mean it relates to the general supervisory jurisdiction of the courts. What it means is it relates to the appellate jurisdiction. And so, under no circumstance can any section in statute or any provision of statute provide to oust the supervisory jurisdiction of the court, because same will be inconsistent with the provisions of the Constitution.
Thank you. May we please see the cases you wrote down there? Thank you.
You may also see Section 57 of the Courts Act. Please, can we proceed?
Yes, please.
Great. So please, if you see the term shall be deemed final, that is the current position in Ghana. Now let's go into the Constitution proper and look at Articles 132 and 141. If anybody has their 92 Constitution, please read Article 132.
Article 132. It says, the Supreme Court shall have supervisory jurisdiction over all courts and over any adjudicating authority, and may, in the exercise of that supervisory jurisdiction, issue orders and directions for the purpose of enforcing or securing the enforcement of its supervisory jurisdiction.
Excellent. Please read Article 141 as well.
Okay. Article 141, it says, the High Court shall have supervisory jurisdiction over all lower courts and any lower adjudicating authority, and may, in the exercise of that jurisdiction, issue orders and directions for the purpose of enforcing or securing the enforcement of its supervisory powers.
Great. Please read Article 161 then.
Okay. Article 161, it says, in this chapter, unless the context otherwise requires, court includes a tribunal. Judicial office means A, the office of a person presiding over a lower court or tribunal, howsoever described. B, the office of the judicial secretary or registrar of the superior court. C, such other officers connected with any court as may be prescribed by constitutional instruments, may by the Chief Justice acting in accordance with the advice of the Judicial Council and with the approval of the President.
So
Judicial
please
officer.
skip to the part where it says supervisory jurisdictions. It's under the C ambit.
Okay, says
It's the
judicial.
last. Yes.
Okay. Supervisory jurisdiction, is that it?
Yes.
Okay. Supervisory jurisdiction includes jurisdiction to issue writs or others in the nature of habeas corpus, certiorari, mandamus, prohibition, and quo warranto.
Great. So the Supreme Court and the High Court are the two courts with supervisory jurisdiction in Ghana. It goes without saying. And in the exercise of that supervisory jurisdiction, they have the power to issue writs in the nature of habeas corpus, certiorari, mandamus, prohibition, and quo warranto. And you'd find that sections 15 and 16, section 5, sorry, and 16 of the Courts Act provide the same jurisdiction. The courts have clarified that in the exercise of its supervisory jurisdiction, they are not necessarily limited to these prerogative writs. There may be any such orders as is necessary to give effect to the supervisory jurisdiction of the courts. So you may see the case of ex parte Mamponsus 2 and ex parte Sleepy Mensa. Both decisions clarify that there are other orders. I mean, if they can be so correctly framed, in which the Supreme Court would be able to grant or outline certain positions in respect of the remedies available to a party as it relates to its supervisory jurisdiction. Now, yes, Abena, go ahead. Abena, your hand is up. If you have a question, you may please unmute your microphone and go ahead.
Sorry, it's a mistake. Okay.
Okay. So lower courts, adjudicating authorities, chieftaincy tribunals, labor commission, SHRAJ, they are all subject to the supervisory jurisdiction of the ordinary courts. And so I guess my question is that is SHRAJ immune from the supervisory jurisdiction? I mean, SHRAJ is an independent constitutional body. And so if a person is claiming that SHRAJ has acted ultra vires or a decision in respect of their investigation is inconsistent with the principles of law, would the High Court have review jurisdiction over SHRAJ? Does the High Court have review jurisdiction over SHRAJ?
Yes, it does.
Yeah. Yes, it does.
It's not okay to just say it does. Why?
Article 141.
Article 141.
I mean, when we read it's clearly said that it gives the High Court the supervisory jurisdiction over not just lower courts, but any lower adjudicating authority.
Okay.
And SHRAJ is a lower adjudicating authority. So automatically, the High Court will have supervisory jurisdiction over it.
Absolutely. So, in SHRAJ's case, there has been a positive determination that the SHRAJ Act cannot purpose to render SHRAJ from the supervisory jurisdiction of the High Court. You may see the cases of Chulum Adamu against UCC and SHRAJ, and then Republic versus High Court Accra, ex parte SHRAJ, Kwame Adu, interested party. Now, before we look into our supervisory jurisdiction ambits clearly, we must go back to our rule of law underpinnings. And the rule of law underpinnings and our understanding of judicial review is very important from constitutional law. You have to remember that judicial review is a power granted to the courts, especially in the common law architecture, that allows the courts to invalidate acts of parliament or acts of the executive that are inconsistent with the constitution. And there are two ways in which judicial review has been understood, i.e. judicial review of legislative action and judicial review of administrative action. And for a decision to be amenable by way of judicial review in terms of a prerogative right, certain criteria must have been met. And just citing or just taking a step back, judicial review of legislative action is what we see in Article 2.1 of the Constitution, where the Supreme Court has the power to determine any act that's of Parliament or any action of any person that is inconsistent with the provisions of the Constitution. The Supreme Court has that exclusive power to strike it down as being inconsistent with the 92. In respect of administrative actions, when an administrative body or a public law body has acted in a certain way, then we can determine that judicial review of administrative action may kick in, and then the courts can also issue appropriate orders in respect of those actions. Now, the Council for Civil Service against Minister for Civil Service outlined the grounds for the grant of judicial review to include illegality, irrationality, procedural impropriety. So illegality, irrationality, or warranty unreasonableness, and procedural impropriety are the grounds under which the court will likely intervene in respect of the exercise of an administrative power. In terms of illegality, is that the action taken by the administrative body was illegal on the face of the record, that they do not even have the power to do so. In that instance, judicial review will be available to a party. Or where the party has acted so unreasonably that in the eyes of right-thinking members of society, such an action cannot stand legal muster, then we say that it is amenable to judicial review by way of prerogative rights. So irrationality or warranty unreasonableness, simply that the decision taken by the public body is so outrageous in the minds of right-thinking members of society or accepted moral standards that no reasonable person, given the circumstances, would have reached such a conclusion, is also a situation where judicial review will arise. Then there's procedural impropriety. So a situation where statutes or some agreement has laid down the process in which something ought to be done and same has not been complied with, then we note that this is a situation where judicial review of administrative action will arise. The reason this is important is that our understanding of the supervisory jurisdiction of the courts is such that the supervisory jurisdiction of the courts can only be triggered when one is alleging that there has been an illegality, irrationality on the part of the decision maker in terms of an administrative body, or procedural impropriety. This would form the scope under which a decision will be amenable to judicial review and subject to the operation of the prerogative rights, which we are all very much aware of by now. Is there a question? I believe not. Which we are all very much aware of by now. Now, of the prerogative rights, and Jody, if you could go back and read the meaning of supervisory jurisdiction in 161 again, please.
Article 161. Supervisory jurisdiction includes jurisdiction to issue writs or others in the nature of habeas corpus, certiorari, mandamus, prohibition, and quo warranto.
Great. So there are several, these are the prerogative writs that we are aware of, but the ones that usually cause trouble for us are the ones that raise several questions of law multiple times, and the ones that we are concerned with for our purposes here in interpretation is usually what is referred to as certiorari, the writ of certiorari. Who can give me a simple definition for what certiorari is? What's a certiorari?
maybe an application. Hello.
Yes, go ahead.
An application to a court of competent jurisdiction to make to quash a decision of an adjudicating or administrative body based on stated grounds.
Okay. So simply put, certiorari is a writ by which a higher court, in our case, only two courts have the power to issue certiorari: the Supreme Court and the High Court. It is it's a writ by which a superior court and is called upon to review the decision of either a lower court or an administrative body or tribunal. So, in respect of certiorari, our understanding is that it is a remedy available to a party that is alleging that, like Mr. Lancelot said, specific grounds have occurred, and when those specific grounds occur, they ground the situation where a person may bring an action for certiorari. There's a difference between an application for certiorari or a writ of certiorari and an appeal. Now, ordinarily, when you lose a matter in the course of competent jurisdiction, you have a right of appeal. And depending on where the matter originates from, you may appeal to the higher court in respect of the hierarchy of courts. An appeal looks at the merits of the case, while certiorari focuses on the procedure or the manner, the process in which the decision was rendered. The previous position adopted by our courts were that a party could not appeal and also apply for certiorari. They were mutually exclusive. So when a party has lost a matter, the remedy available to him would either be to appeal or to bring an action for certiorari. But the position adopted by the courts now is that they are not mutually exclusive. The court has clarified in the case of ex parte Ghana Cocoa Board that because both rights are constitutional and statutory, a party is not precluded from having the right to appeal and also invoking the jurisdiction of the courts in terms of its supervisory jurisdiction. So you would note that, for instance, in the Anas Aremia or Anas versus I believe Kennedy Japan case in respect of the defamation suit that Anas brought against Honorable Kennedy Japan, Anas has appealed the matter, but he also invoked the supervisory jurisdiction of the Supreme Court. So there's a pending appeal at the High Court, but he also invoked the supervisory jurisdiction of the Supreme Court to quash the decision of the High Court based on certain grounds that he outlined in his application. And so it tells you that that position is now the firm position of the law. And I mean, it didn't come up for consideration in the court at all. That because he had appealed, he was stopped from filing for a writ of certiorari. What the court noted rather was that he had not met. So the court, in refuting the grant of certiorari by, I think it was a 4-3 split, outlined that he had not met the grounds for the grant of the remedy of certiorari, and that it appeared that the grievances that he was complaining about were more likely matters that ought to be determined by way of appeal. And so, in that respect, the court will not grant the remedy of certiorari. So, just by way of introduction to certiorari, a party can appeal and also invoke the supervisory jurisdiction of the Supreme Court or High Court in respect of the grounds of certiorari. But it must be noted that before we go into the grounds for the grant of certiorari, the first thing we must note is that it is a discretionary remedy. And so the court would grant it only on specified grounds. And the court has the power to determine, in the circumstances of the case, if it's appropriate to grant that remedy. You may see the case of ex parte Ampon, aka Akrofa Krokoko, Trefo the Third, and others interested parties in respect of the fact that the grant of the remedy of certiorari is discretionary. The party is not entitled to it as of right. Now, the courts over time have developed the grounds for the invocation of the remedy of certiorari, and they have outlined that a party may first allege a breach of the rules of natural justice. So, if you recall, the two legs of that rule are the audi autem pacem rule and the nemo judex in causa sua element in respect of the principles of natural justice. And so, if any of the legs are breached, you may bring an action in respect of a higher court. So, if it's a lower court or an inferior tribunal that rendered the decision and same was contrary to the principles of natural justice, you may invoke the jurisdiction of either the high court in respect of the lower body or tribunal, or if the high court is the one that did that, you may do same in the Supreme Court, alleging that there's been a breach of the rules of natural justice. So you find, for instance, in the Opunu case, in one of the many Opunu cases anyway, one of the grounds the party alleged in the invocation of certiorari was that there was a clear bias on the part of the judge, the High Court judge who was hearing the matter. And so the remedy was being sought to restrain the judge in respect of to quash the decision of the judge and further prohibits the judge to continue from hearing the matter. The next one is where a court lacks jurisdiction or exceeds its jurisdiction. So when there's a want or there's an excess of jurisdiction, then we have a situation where a party can validly invoke the supervisory jurisdiction of the court for a grant of certiorari. Then when there's an error on the face of the record. Now, what an error on the face of the record means is still the subject of considerable confusion in terms of what it means. You should look at the case of ex parte industrialization fund for developing countries. I'll type it for you. Ex parte industrialization fund for developing countries. 1 second, please. Yes. The error must be one that goes to the root of the decision, such that it renders the decision a nullity. So it is an error that has been made by the court or the court with the original jurisdiction hearing the claim, or the tribunal with jurisdiction hearing the claim, that is patent on the face of the record and goes to the roots of the matter, such that the error is so grave that it renders the decision a nullity. If it is a mere error of fact or law that is not apparent on the face of the ruling, or that is not so fundamental, the avenue for redress is by way of an appeal. And so it's important that a party is not merely alleging that the judge committed an error, but the error must be patent on the face of the record, and the error must be one which amounts to a lack of jurisdiction of the court, which in effect renders the decision a nullity. That is what the guidance the Supreme Court has given us as to what it means to say error on the face of the record. And in terms of the Wensby principles of unreasonableness, so when the decision rendered by the adjudicator or by the inferior body is so irrational, outrageous, that it defies logic, then it may form grounds for the invocation on the grounds in terms of certiorari. You may see the case of TDC against Musa and Atabafo, where the court outlined this position as well. And there are some authorities that also demonstrate to us that the court may also intervene to ensure justice. Now, in ex parte electoral commission, the court said the Supreme Court, so this is not a remedy available to a party in the High Court, but the Supreme Court under certain circumscribed grounds, may intervene in terms of certiorari to ensure the prevalence of justice, equity, and fairness. To finish on this certiorari matter, it used to also be the position that a party needed locus to be able to bring an action in certiorari, i.e., if you are not a party to the original suit, you have no business or you have no standing to bring an action in certiorari in terms of invoking the supervisory jurisdiction of the courts. But that position has now been dispensed with. The current understanding is that in the interest of the public, so in terms of public interest, the court will allow an intervention by busybodies, parties who are not necessarily in terms of the original suit, parties to the suit, but they will be allowed to bring an action in terms of the supervisory jurisdiction of the court. This, has a tendency of, unnecessarily prolonging the dispute resolution process and can be severely abused. But the understanding we have now, based on the position expressed by the Supreme Court in ex parte deal with the II, is that a busybody or a party who is not an original to the suit may bring an action in respect of a supervisory jurisdiction of the courts, and the court may intervene, especially when it believes that it is in the public interest to do so. Any questions? Great. Next week, we continue with ouster clauses. We'll be looking at ouster clauses that relates to causes or matters affecting chieftaincy. And then we'll look at the conferment of jurisdiction on administrative bodies and whether it has the jurisdiction of the High Court per se. And then we may look at some questions in relation to ouster clauses. So that would form the scope of our discussions next week. Any questions, outstanding contributions? In the absence of that, I believe today has been productive, and see you next time.
Thank you. Thank you very much.
Thank you.
Thank you.
Most grateful.
Thank you.
Thank you.
Obi Baha. Obi Baha.